Hello, Sean. Welcome.
Hello.
So we're just getting started here, and I'm looking at the time. I think we should be starting quite soon. I'd like to ask our colleagues from Kokobo if they're ready, and we have our moderator today is Arnold from CLISC. And I'd like to ask our colleagues from Kokobo, will Edward be joining us? Or should Arnold make a start?
Yes, Teresa, what did you ask?
So I asked if Edward Sigi will be joining us for the webinar, or if we should make a start.
No, he's not joining us. He sent an apology. He's not joining us. We can just start.
Okay, great. So am I talking to Faith?
Yes, this is Faith.
Okay, oh great. Nice to meet you.
Nice to meet you too.
All right, so thank you. So Arnold, I think we can kick off. There's a number of participants who have logged in, so I think we should get started. And yeah, let's get started. Thank you.
Thank you very much, Teresa. So good afternoon, everyone. I think for Teresa, it's good morning because it's 6:30 a.m., I believe, yeah? And I believe we also have some colleagues joining in from Dublin. So good afternoon to those of you in Johannesburg. So Arnold Mwanzu, I'll be your moderator for the day, standing in for Professor Joseph Kavulia, who is the CLISC chair. He was not able to join us today because of some few things. However, I will try my best to make sure there's no gap. So I'm standing in for him as the secretary of CLISC. For those of us who are not familiar with CLISC, CLISC is the Kenya Libraries Information Services Consortium. So today, this is marking the third webinar series. We've been having a series of webinars in cooperation with Kokobo and IFEL. And today we'll be looking at issues of artificial intelligence, text and data mining, and big data. So just like the previous webinar series, we have a panel of experts who will be here with us together to help us understand some of these issues. And some of the issues that will be discussed today are, of course, introducing copyright issues relating to artificial intelligence, text data mining, and big data. We'll also be getting insight from national and international experts on the context of copyright and artificial intelligence. We also want to understand some of the policy issues and legal gaps in Kenyan copyright law. And to help us understand that, we have advocates, we have lawyers who will be part of the panel, experts in matters copyright, to give us an understanding of these matters and how the policy issues actually affected. And then we'll also want to identify the next steps in terms of facilitating artificial intelligence at a national and international level. And internationally, we actually have a colleague of ours from American University, Washington College of Law, who actually works together with the rights to research in international copyright law, which who will be actually helping us to understand these matters in international level. So the webinar is being hosted by Kokobo in partnership with the IFEL and CLISC and Right to Research in International Copyright Law. So this webinar is going to be held for 2 hours. We'll start with our guests, our speakers, just giving us some presentations, and then later on we'll have a panel discussion where we'll open the floor and people will ask questions and answers. So I'll request those of you who have questions, please just note them down, or you could also just type them on the chat. My colleague Teresa will assist me in picking those questions so that later on our panelists will be able to answer. So before I start welcoming our first speaker, I would also just like to recognize that the audience of this webinar, we have policymakers, we have researchers and artificial intelligence developers. We also have representatives from research institutions and universities. We have librarians in place, and sorry, we also have lawyers. So this is a diverse audience, and we are all here to understand these issues of copyright in artificial intelligence, text, and data mining. So please feel free to ask questions. We'll be able to take them and answer them at the end of the program. So as you've heard from our colleague from Kekobo, the CEO of Kekobo, Mr. Edward Sigei, was not able to join us today. He was supposed to give us the welcome remarks, so we will skip that part. We're also expecting to hear from the CEO of Kennet, Professor Kashoda, but again, Professor Kashoda will not be able to join us today. So our first speaker of the day is going to be Angela Wairegi. Angela Wairegi, if I can just give a brief bio of Angela. Angela is a research fellow at the Center for Intellectual Property and Information Technology. She holds degrees in chemistry, food science, and a PhD in physical chemistry. She's an experienced educator and a research scientist with a proven track record in designing educational and training programs for scholars in the scientific field for online and conventional classrooms that cater to the educational needs of diverse student populations, as well as the strategies required for carrying out systematic, comprehensive, and successful research projects. So Angela, I would like to invite you to give us your presentation. Of course, Angela will speak to us for about 10 minutes, and then I'll invite the next speaker. So Angela, over to you.
Good morning, everyone. Good evening, depending on where you are. It's actually Angeline, not Angela, it's Angeline.
Sorry about that.
No, you're
Angeline.
fine.
Right.
If I could share my screen, my presentation. All right, please let me know if you can't see the screen or if I drop off. I've been having Wi-Fi issues on and off. So my name is Angeline Wairegi. I am the AI project lead at CIPIT. CIPIT is a research center and think tank based in Nairobi, Kenya, and would focus primarily on issues of IP, ICT, and emerging technologies. So I'll just be giving a brief overview of AI in Africa. So the opportunities that we have, the obstacles, and ethical considerations moving forward. So before we focus in on Africa, I think it's prudent for us to define what AI is. So artificial intelligence is really computer systems that are designed to mimic human intelligence, which simply means that they can evolve past a particular starting point to solve problems more efficiently. So that's basically the general purpose of creating AI programs, is we believe they have they're more efficient, or can be more efficient than humans in solving some issues. So the AI ecosystem in Africa is fairly new, comparatively speaking. If we were going to look at it in comparison with AI ecosystems in the US or in Europe or in China, we're fairly new to the game, but there is a healthy ecosystem developing here in terms of development and also in terms of adoption. So we are still primarily consumers of AI, meaning that we tend to import AI technology. So things like
sorry, Angeline, can I
yes.
just request if you could use the presenter view so that we could follow your slides? Is that okay?
Oh, yeah, sorry.
Thank you.
Hold on. I'm sorry. How do I do that? How do I do?
Can you see there's an icon at the bottom right that looks like a television, sort of like. If you could just click on that, that's the presenter view. While sharing.
Can't on the bottom. Sorry.
We lost your screen share, so I can't direct you. Maybe you could share, and then so I could advise.
Okay. Okay. So bottom right.
Bottom right, there's an icon that looks like a TV. Can you see it next to the zoom out?
Oh, is it this one? Slideshow?
Yes, that's it.
Okay. Sorry about that. Is that better?
I'm waiting for it to reflect on my side.
Okay.
Did you click on it already?
Yes, I did. I did.
Well, it doesn't seem to show on my side. Okay, the other option is just go to slideshow on your menu bar. Can you see your menu bar at the top?
Yes.
Go to slideshow where it's written slideshow. Can you see it?
Yes. Yep.
Yeah, just click on it.
Mm-hmm.
And then say present from beginning.
Okay.
From beginning, just click from beginning.
Okay, I've done that. It should be the first page now. Is it not showing?
Yeah, that's strange. Not yet. Okay, I think there's a problem with Teams. Maybe you can just proceed. We'll work with that.
You know what? Let me put off my video because sometimes that's. And then let's try this again.
Okay.
Anything?
You haven't shared, so.
Oh, it says that Team Microsoft is sharing a window, so it's sharing on my side.
Oh, okay. Oh, it's not. Oh, so it's maybe what you want to do is to share your entire screen so that when you click on presenter mode, we can see it. Yeah.
Okay.
Stop share and then just say share entire screen and then now go to.
All right. Okay, anything?
Unfortunately, no, but I think let's just continue.
Okay,
it's fine.
let's just
We'll work with that. Yeah, it's okay.
All right. Yeah, I'm not sure because it's showing on my side, so I'm not quite sure. All right. So I was talking about the development process. So development of AI in Africa. We do have an emerging AI ecosystem in Africa. We do have startups that are coming in that are present on the continent. But primarily, as I stated earlier, we are still primarily consumers, not developers. But for the developers on here, what they tend to use to develop AI is open source algorithms and non-local data sets. So I should have mentioned this earlier. In AI, the two main things that you need are code to tell the system what to do. That's your algorithm. And then you also need to train it for it to evolve. And that's where your data sets come in. So in general, the developers on the continent are using open source algorithms, meaning they're not writing the code from scratch. They tend to use code that's been provided by other organizations, so maybe the Googles or the Microsofts, and then modify that to local problems. And then also the data sets that we're using to train this algorithms tend to be non-local, again, meaning they've been obtained either from the US or Europe or China, the big three AI players globally, and then we use those to develop our systems. So there's good and bad points to that. The reason where we're developing AI and fintech. So the motivations for developing AI here are a little bit more narrowly focused, I think, or maybe maybe there are other challenges that lead to this. But when you look at AI developed in the US, for example, we have AI for autonomous vehicles. We have AI developed just for gaming systems. We have AI developed for entertainment, but we're not really seeing that here yet. So we're still primarily looking at it to solve the challenges that I just mentioned. So the lacking infrastructure, insufficient labor, limited access. Of the four sectors that I've mentioned, we are seeing the most development in the agricultural sector, and that's for a variety of reasons. So we have AI apps that are being developed to provide financial aid. So maybe they're being developed to help smallholder farmers to obtain loans. We have AI being developed to provide information on soil health, on irrigation patterns, on crop diseases. We also have AI being developed to help the farmer navigate the value chain. So you are usually helping farmers get their produce or their animals from the farms to the marketplace. So what are the obstacles facing AI development and adoption in Africa? I think the largest one would be our lacking digital infrastructure. We still have very limited Wi-Fi in a lot of places on the continent. And we also tend to have an urban-rural divide, even when we have a nation that has internet capacity or digital infrastructure. We tend to have this concentrated in the urban areas, which leads to disenfranchisement of people in the rural regions because they can't access these tools. Also, if we are lacking digital infrastructure, that curtails our AI development because creating these AI platforms requires a lot of data. It requires a lot of computing manpower, and we need digital infrastructure for that. Also hindering AI development is limited financial resources. There tends to be a very small pool of financiers for AI development on the continent. It's still generally being led by private industries. Government is interested, it is getting interested in AI, but I don't think it's fully dipped its toes in the water as it may be. So the competition for the amount of financing is fierce. Financial resources also hinder the adoption of AI in that you need to be able to afford these tools. So tools meaning laptops or smartphones. You need to be able to afford them to be able to access, AI technology. And that's not the case for everyone on the continent. So there is asymmetries in terms of fiscal access. We also have a comparatively small labor pool in developing AI. There are certain skill sets that are needed to be able to create these tools, and we still have a very fairly small labor pool to draw from if we compare that to the US or the EU or even China. And in general, we have issues of equity in terms of access and in terms of benefiting from AI. And this is for a variety of reasons. I've already discussed the fiscal angle, but also in terms of bias, sometimes we have a gender bias that hinders participation in AI, whether that's from the labor or workforce perspective. So we did a mapping of gender disparity in AI, CIPIT did last year, and we found that there was a significant difference when you compare the numbers of women in this AI workforce. Also, we have cultural and social ingrained perspectives that might play a factor in terms of access as well here, and also vulnerable communities, so displaced people, for example, they also have issues accessing these tools. So a lot of challenges in fully adopting AI platforms and also in the development process of AI. When it comes to governance structures, we don't really have any laws in the book that are specific to AI. We do have a number of national or regional mandates concerning AI. So for example, the African Union in 2019 put out a mandate for its member states saying that they should look into the utilization of AI and how it can impact economic progress in their countries. We also have regions, we also have nations, excuse me, that have come up with AI strategies. So Kenya being one. We have a blockchain AI task force that was developed in 2019. We also have AI strategies in Rwanda, Zimbabwe, Botswana, a number of African countries, but we haven't really seen what that has led to as of yet. So they might still be going through the working process for these groups, but we haven't really seen any output from that. And then finally, I'd like to talk about the ethical considerations that we should think about in terms of policies for AI going forward. So I think the way that AI is discussed globally, I think, but specific to Africa, is as this silver bullet for everything that ails us. But there is concern that AI might actually increase the pre-existing inequalities that we have on the continent. So the people who would benefit would be the people who are already in power, whether it's political power or financial power, and then it would lead to even more disenfranchisement of other groups. So when we are considering how to move forward with AI or building this AI ecosystem, I think we need to have policies that address issues of access, issues of equity, issues of privacy, and issues of knowledge asymmetries. So the knowledge asymmetries I haven't really touched on, but I think one of the challenges that we have here on the continent that might maybe be more of a factor here than elsewhere is the issues of data and digital illiteracy. So digital illiteracy just meaning that there might be a gap in people's knowledge of how to navigate things like smartphones or just general technological tools, let alone AI. And we need to address this if people are to be able to equally benefit from AI. Also for data, I think there isn't a lot of knowledge or discussion on why data is important, or what data is to begin with, why it's important, and why people should be concerned about it. And I think that also needs to be addressed when we're talking about AI, because there's a big there are big challenges when it comes to data in general, and data is a big part of AI. So I think that that's something that needs to be discussed as well. And also issues of privacy. So we need to consider how adopting these AI tools will affect data privacy, one, and just general privacy of individuals. So we have surveillance systems that are being deployed on the continent, and there hasn't really been any critical studies or critical observations on what exactly surveillance entails and what that data being collected is being used for afterwards. So I think going forward, any policies, any laws really need to address these 4 factors if we were to build an equitable AI system on the continent. Thank you.
Thank you so much, Angeline. That was a great introduction to artificial intelligence. As I mentioned earlier on, we have a diverse group of participants today. And Angeline has been able to give us an insight of artificial intelligence and big data and how it is actually used in Kenya. And maybe just to also echo Angeline's sentiments, that for any of you who are not familiar with this concept, Kekobo is currently running a Twitter thread. So if you could go to their Twitter page, there's some brief introductions on artificial intelligence, text data mining, and big data. So again, I would like to urge all of you, if you have any questions, please feel free to type them on the chat box. We'll take your questions, and then at the end of the session, we'll have all the panelists answer to some of these questions. So next, after Angeline, we were actually supposed to have a brief insight about the Kenyan universities. As you've heard from Angeline, some of the obstacles that we are facing in terms of artificial intelligence is a lack of digital infrastructure, limited resources, and a small labor pool. So KENNET, KENNET actually stands for Kenya Education Network, have played a big role in Kenya in terms of providing infrastructure to enable things like artificial intelligence, big data, and specifically in universities. So I would have wished if Prof was here, he could have given us insight on how AI is being used in Kenyan universities. Nonetheless, during our Q&A session, I believe we have maybe one person from KENNET, or even not, we'll have maybe a faculty or a librarian from one of these universities to just share some of the experiences in terms of using artificial intelligence in Kenyan universities. So at this point in time, I would like to move on to the next speaker. I mentioned earlier that we'll get some international, insights from the international sphere. And to help us with that is Sean Flynn. Sean Flynn is the Associate Director of the Program on Information Justice and Intellectual Property, PIJIP. And also, he is a faculty, I believe, at the American University in Washington, College of Law. So Sean will actually just take up from where Angeline left and now give us an international perspective on how AI and copyright law, work together in the international aspect. So over to you, Sean. Welcome.
Thank you, Arnold. It's thank you for having me. This is a really exciting program. I've long actually been looking at all the programs that Kekobo puts on, and it's just, I want to commend you for taking this field really forward and making sure that you are educating and looking at issues at intersection between public policy and intellectual property. And it's just a great service you're doing for everyone. So, Yeah, I'm absolutely going to try to take us to the next step. That was a great initial introduction into some of the, benefits and even policy issues around artificial intelligence. And let's see. I'm going to make sure that I can share properly. Let's see if I can do this. Okay, how are we? Are we having the same problem, or is the slides showing properly now, Arnold?
This is perfect, Sean. We can see
Okay,
it
perfect.
clearly.
Okay.
Thank you.
Okay,
Right.
good. So I'm going to talk about the intersection between copyright and what we refer to as the right to research, because when you think about what researchers do, aren't they at their essence receiving information and imparting information? Receiving information and delivering information. And those two concepts, and actually I'm taking their exact words, is the explanation of the right to freedom of expression in Article 19 of the Universal Declaration of Human Rights, for instance, and is reflected in the Kenyan Constitution and the Constitution of nearly every African country. So what researchers do, we need to recognize, is really much part of the human rights infrastructure. And of course, there are also human rights to protect the moral and material interests of authors, that copyright-like human rights protection. And so our policies need to constantly be moving forward in a balancing of these two interests to bring them together and to not make them conflict. So we had some examples just now of artificial intelligence. I'll give you a couple more just to kind of seed your frame for thinking about these issues. So the first, totally relevant to us all, is that it was actually an artificial intelligence firm, private firm, that first found the outbreak of the coronavirus using text and data mining. So it was digesting newspaper articles, data from governments, announcements, etc., comparing them to travel records, found through that process a spreading virus and alerted its members to it. So it was an artificial intelligence firm in Canada, small firm in Canada, operating under their copyright law, which allows a right to research, which discovered the virus. And then the second is an equity problem, though. And this was raised by the last speakers, but who benefits from artificial intelligence? Who's able to do artificial intelligence? Who are the producers and who are the consumers? And part of that question is shaped by our laws. So in order to participate in artificial intelligence or text and data mining processes, maybe I'll pause there and just say text and data mining refers to the digesting of large amounts of content in order to have algorithms crawl over that content and learn from it. So it is the first step towards artificial intelligence. And artificial intelligence is usually refers to what a program or some kind of machine does at the backside on the outside of that text and data mining. So before you have artificial intelligence, you almost always need to have text and data mining first. It's a first step. So how do you do text and data mining research? First, you need rights to reproduce. You need to produce often whole works. So we teach machines to learn pictures by feeding them tons of pictures, usually from the internet. So you need to be able to copy those pictures and feed them into the machine to learn from them. All different kinds of users need to be able to do that for the purpose of computational use, or sometimes we call it non-expressive use, but so that's for the purpose of analysis rather than to enjoy the work, right? And then you sometimes need communication rights. You need to be able to share those materials with other researchers for the purpose of collaboration or through validation. And that sharing can take place across borders as well, as it often does in Africa, for instance. Many researchers are doing research with researchers living in other places, whether they live in South Africa or live in Uganda, etc. So we in our project have been doing empirical research, which shows some of the outputs of having more flexible copyright systems that allow this kind of text and data mining to go on. And so Mike Palmetto's research finds, for instance, that having more open general research exceptions in your law is correlated with more production of citable research. Or Christian Hanke is looking specifically about whether the law authorizes either text and data mining or has an open exception, and is looking at text and data mining academic research. So published articles that say that they're using that text and data mining methodology. So the short of it is that there appears to be evidence that having better copyright laws leads to more research. So what do those better copyright laws look like? So this version of a map of the world divides the world into these 6 different categories. You can focus first on the red and the green and then every other color, right? So in the red countries, the copyright exceptions don't allow text and data mining because they only allow uses of excerpts of works, doesn't allow whole works. In the green countries, there's a broad research exception that applies to uses of any kind of work for a research use by any user. And so framed that way, it really is broad enough to allow text and data mining research. And then all the other countries have some kind of a restriction. In the yellow countries, it's a restriction on the kinds of works that you can use. In the purple countries, it's a restriction on the kind of users that can use the work. In the light blue countries, you can only use the material for a private use, which means by that definition, you can't share it, you can't use it for commercial use. And in the dark blue countries, there's a restriction on you can only make reproductions, you can't share. But so basically the green countries are looking pretty good. They have broad enough rights. All the other countries have some kind of problem. But if you look carefully, actually Kenya is in a green country. Kenya and the rest of Southern Africa, and it's common to the countries that have the Commonwealth tradition, because most of those countries have a fair dealing right. And so fair dealing means any use, any protected right. And fair dealing rights apply for use for any purpose. Apply for any research purpose. But they apply to any user and they apply to all the different rights. So the Kenyan law now, if you compare it, for instance, to the US law, for the purpose of research, is very similar to the US fair use right. There's a broad right for a fair dealing for the purposes of scientific research. So actually, with the result of our research looking specifically at Kenya, there doesn't seem to be a copyright problem with doing this kind of work in Kenya. And then that raises a question, but so do people know that? Do we need to spread that information more? Do researchers, I was very happy to hear there's researchers in the room, there's libraries in the room, there's universities in the room. Is this well understood? Is there work that needs to be done in Kenya to make sure that people know you are living in an environment that is as open as the United States for research? Because these practices are being done in places like the United States, and are they being done enough in Kenya? Another option, I know Kenya is I believe is considering some copyright reform now. Correct me if I'm wrong on that. But some countries like Singapore and Japan, for instance, have put in their laws specific exceptions for, and you see in Singapore it's called computational data analysis, or in Japan, the exploitation of a work for use in data analysis. So these are specific exceptions that really say if what you're doing is really text and data mining, you're not using the work to reproduce it and share it with other people just for the purpose of reading or whatever, that data analysis is a protected use under the exceptions. So that's an option that countries like Kenya that already have a general exception could take to make it even more clear. But again, the result of our research is that that step may not be necessary, yet it may be helpful. So what are the implications of what we've done so far? I've shared with you our outcomes of our comparative copyright studies and some of showing there's a large amount of diversity in the world, but Kenya tends to be on the good side of it, that diversity right now. I've shared with you our empirical research that shows that these things matter, that more research does take place in countries that have better laws. So those insights could be used to shape domestic law reform. So in a country like Kenya, one could consider following Singapore and Japan and having a specific computational use right. It could, the lessons could be used for international law reform. So for instance, because we live in a world of so much diversity, collaboration is difficult, especially between countries that are in that green or, that's in that kind of yellow or red parts of the world. So in those places, it may be legally blocked or at least uncertain whether you can share materials between countries. So one of our ideas has been, and published an article on this with some other law professors, is what about having like a Marrakesh style provision that allows cross-border uses of lawfully made materials? If you do that, then it would make very clear that countries could collaborate across borders as long as they were collaborating with at least one entity, researcher in one of the green countries where you have maximum rights. And then finally, one of the issues we could be doing is just information exchange. For instance, in Kenya, is there enough information being exchanged that people know what their rights are so that they don't have to feel that the law doesn't allow what they're doing? This could be, for instance, in the form of interpretation or guidance by Kakebo, or another institute of government, or even by scholars, or best practices statements, things like that, to help inform people what they can do, so people don't feel like the law is in their way when it doesn't appear to be. So with that, I'll end my presentation for here. I would like to note that I'm going to have to leave this meeting at 2 p.m. because I have another meeting actually with some African colleagues as well that starts at 2. But I will be looking at the chat, and I'll be happy to answer any questions in the chat and things like that if I'm not able to attend the roundtable. So thank you very much. Arnold, over to you.
Thank you, Sean. I think that was very insightful. Some of the things that caught my eye is that artificial intelligence helped to predict COVID-19. So I'm just thinking perhaps we should be more on the lookout to AI to know what's the next outbreak. I don't know. Yeah, but so colleagues, this presentation, as Sean has given us really good insight, international insight. Has given us some of the examples of some of the laws in place, how countries like Japan and Singapore have adopted the international law reform just to accommodate text data mining. So I think what I can get also is that for us the implications is that at least Kenya is green, and I'm happy to learn that Kenya is on the green side, embracing fair dealing rights for scientific research. And I think some of the participants in this meeting, including faculty and librarians, have taken a big role in ensuring this openness. We know we have quite a number of institutional repositories. We have initiatives on big data, which is open big data from some of the research institutions like KEMRI and ICIPE and even AMREF, I believe. So that is quite good. I continue to encourage colleagues, participants, if you have any questions, please post them on the chat. And since Sean actually finished his presentation 5 minutes earlier, maybe we could pick 1 or 2 questions before he leaves. He's just indicated that he's about to leave
Sure.
in the next minutes. So I would like to break the program and just take a few questions for Sean before I invite our next speaker. So any questions? We have our administrator who is going to allow you to unmute yourself. So I'm looking at the hands. If anyone had put their hands up by mistake, please put them down so that now we only get questions directed to Sean. Any questions, please?
I think Richard
Omolo. Yeah, Richard Omolo,
Yeah.
I believe this is from Jomo Kenyatta University. Richard, please go ahead. I'll request the admin to allow him, unmute him so that he can ask his questions. Richard, please go ahead. Okay. Or any other question as we wait for Richard? Any comment?
I'm on now.
There
Yes,
he
please,
is.
please go ahead, Richard. Yeah.
Well, I'm looking at the situation of the copyright versus AI in a situation where they are now using other machines like the drone to be able to get information. On the internet, they are using the bots, some of the bots that people are not able to detect when it is picking some information from either your site or account. How do we deal with it when it comes to copyright?
Thank you, Richard.
And so is the question, so you mentioned one of the ways that artificial intelligence programs can inform themselves is through research on the internet, right, with bots or things like that that are scrolling over the internet and collecting information to learn from, right? Yeah, and so that can be true, assuming that there's the rights to do that, in the different countries. And so researchers do use that information to inform various kinds of research projects. And then what's the question was, how do we deal with it from which perspective? You had a concern, I think, but help me catch it.
From the copyright perspective, when now we want to protect persons' intellectual property, and as well as on the other side, the AI is fighting to pick automatically some information from the internet, some of which may be from the accounts of those individual owners of the research. How do we now enforce the copyright law to protect the intellectual content and at the same time deal with a situation where we want to enhance AI to continue to do more in the research field?
Yeah, so there's a couple different options there, and I can, cite to you, different examples. So in the EU, they've enacted a specific data mining exception at the regional level that includes each country to implement, and they distinguish between like academic research, non-commercial research, academic university researchers, etc., and then commercial uses. And the academic researchers have a right to use any of that information on the website, etc., as long as it's public. So this isn't a right to kind of go behind the wall and find things on your computer or whatever. So, but if it's if you released a blog on a website, for instance, so could an academic researcher crawl that blog, use your text to train a translation machine or some other AI thing? And the answer in the EU would be yes, you can definitely do it if you're doing it for non-commercial purposes. If you're doing it for commercial purposes, then you have to elect websites to opt out. So you could put on your website no commercial crawling, or something like that. So Google has a similar option on their search tool where you can delist your website from a Google search. So you tell Google, I don't want to be searched on Google. Now, most people do want, right, to be searched by Google, but the EU is saying you can do a similar option for text and data mining. Now, the other option would be like Singapore, for instance. Singapore, there's no opt-out. So any researcher, whether it be commercial or non-commercial, has a right to access and use that publicly released information on the internet or whatever for a computational analysis project, and it doesn't matter whether it's a commercial or non-commercial use. So that's a decision that Singapore made to not have an opt-out. So you can have an opt-out or you can not have an opt-out, and there's different countries have gone different ways on that.
Thank you so much, Sean. That was a great question from Richard. I know that's a trending topic right now. There's a lot going on the internet, all websites asking you for permission. People don't have the right knowledge to know what to allow and what not to allow. So I'll leave the rest for the panel, Q&A session. At this point, I would also like to, I think it would be good that while Sean is still here to get some insight from, the case in Kenya. And to help us with that is Ms. Faith Omondi. So Ms. Faith Omondi is
Hello. Hello. Have we lost Richard?
Oh,
or
sorry.
Arnold?
I'm still
Arnold,
on.
are you there?
Sorry, I thought I was sorry, I was on mute. Sorry about that.
Okay.
Okay. Yeah, colleagues. So thank you so much, Sean, and for answering the question. I think that was a great question, Richard. And it's a trending topic right now. People are not so sure, what to allow on the internet. There's a lot of crawling going on. You don't know what data they have, and I think we'll have more discussion on that during the Q&A session. So now to bring us closer home, to give us a perspective, a local perspective, just to help us understand what is permitted, how is artificial intelligence recognized in the Kenyan Copyright Act. We have with us Ms. Faith Omondi. Ms. Faith Omondi is a senior legal counsel at Kekobo. And I'm going to ask her to introduce herself further. But what I can say about Faith is that she's an experienced lawyer with a demonstrated history of working in the law industry. She's specialized in intellectual property law, and she's very passionate about emerging technologies. So Faith is going to give us an insight into the Kenyan setting. And again, if you have any questions, please put them on the chat. We'll take them after the session. Over to you, Faith.
Thank you very much, Arnold, for the opportunity. And I also wish to thank all the panelists who have gone before me, and even the ones who will be speaking after I'm done. So you did well with the introduction. I am a senior legal counsel at Kekobo, and I will be giving majorly just the interaction between AI and copyright and what is allowable, because at Kekobo what we deal with majorly is protecting our theme mainly is just about protecting copyright and encouraging creativity. So with the emergence of AI and the creation of works from AI, are they protectable by copyright, and what rights do the authors, if at all, have? So that will be basically what I'll be talking about. Okay, I'm trying to move to the next slide. I hope you are seeing my screen.
Yes, we can see your screen, Faith.
Okay. So I'm trying to move to the next slide. But
yeah, sorry, it seems Microsoft Teams has some challenges. Maybe, do you want to stop sharing and maybe do it again?
Let me stop sharing, and then I can try again.
Yeah. now we can, yes, it's moving now.
Good. Okay, so I'll just basically start by maybe defining what artificial intelligence is. And this is just, in simple terms, in layman's language, it is just a branch of computer science that deals with building smart machines or robots or algorithms which are capable of performing tasks that originally or traditionally are performed by human beings. So it involves the use of machines or algorithms and computer programs and all that, so they do what humans would ordinarily do. And as the presenter who went before, Dr. Sean, he said that AI was even able to predict the coronavirus. So this is something that would ordinarily have been done by a human being, but you find that AI was able to do that. Okay. So I say that it's based on machine learning, and so machine learning is basically the use of computer systems that can learn and adapt without explicit instructions. So you find that once the machine or the algorithm is being trained, after it's been trained, now it can adapt and use whatever learning it gained, and then it can go ahead and do what it's required to do. For example, if it's the prediction based on the data that it has mined and crawled on, it is able to act on it and carry out other further instructions. So these are just some of the ways in which AI is applicable, and our first panelist already mentioned this. She talked about, AI being used in agriculture, it's used in the health sector, and I will also add that it's also used in the creative sector, where we find that we have a lot of creative works or copyright works, so to speak, which have come up as a result of AI, which have been developed as a result of AI. So the question, or the big question, which has been debated over the years ever since AI became a buzzword, is that what is the fate of such works? Are they protectable? And if they are protectable under copyright, who owns that copyright, if at all? So that is what I'll be dealing with majorly. Okay, so it is not moving. Let me stop sharing again, and then I try again. I'm sorry about this. So you can see this is for those who may be familiar with what has been happening in the AI and IP conversations held by WIPO and other organizations. You are familiar with this painting, if I may call it so. This is a painting in quotes that was developed by an AI system. This was around 2016, and it was developed using AI, but of course there were several other players who were involved. So I usually consider this painting, which was a Rembrandt style painting. Rembrandt was just a very famous Dutch painter who lived around 3 or 4 centuries ago, and he was very famous such that it was felt that his style of painting should not be left to disappear. And so the AI was trained on his style of painting, and it was able to develop this kind of masterpiece. So the big question has been, is this painting a copyright work? And if so, who owns the copyright in this painting? Is it the AI? If we talk of the AI, what exactly in the AI? Is it the algorithm? Is it the computer programmer who developed the algorithm? And who exactly owns copyright, if at all? Others have said that it should just be left to be in the public domain, and that is exactly actually when we talk about this painting, that is where it is at the moment. So there are many questions, and from a copyright perspective, other than just looking at who the author is, there are many questions concerning originality. When we talk about the idea expression merger dichotomy, who owns when the idea and the expression are merged such that the originality is lost? So is it still a work that is eligible for copyright protection? Because when you look at this painting, the brains behind it, they were working to ensure that they had an end result, which was a Rembrandt-style painting. So at the end of the day, the algorithm or whatever it is that was developing this painting, did it really have a free creative choice? And these are some of the components that are essential in making a work original and hence making it eligible for copyright protection. So those are the questions that have been asked concerning this. So I stop sharing again. Or maybe I should switch off my camera and then maybe that will make it easier. I hope so.
Yeah, I think that could be the trick.
Yes. Okay, let me try without the camera. Yeah, so there have been several schools of thought, and different countries have had to address this issue of ownership of copyright developed or made from artificial intelligence systems. And the United States has been the most recent one to give a verdict on this. And the application to register this masterpiece that you can see here, it was rejected by the US Copyright Office. And you can read more about it from that link, or even if you just went on Google, you'll find more information about this. The work was titled that, the title of the work was A Recent Entrance to Paradise. So the argument of the US Copyright Office was that it is not developed by a human. The creator was not a human, rather it was a system, it was an algorithm, it was a machine, it was not a human being. So the applicant, Mr. Teller, who was also responsible for the patent application, which was granted in South Africa, I will mention that later, he argued that, you know, this could be considered as a work made for hire, but it was not allowed. So in India, the position is a bit different from the US. They have resolved, or it has been accepted, that an AI-generated work can receive copyright protection if it can be demonstrated that the author of the work, the algorithm developed the work alongside a human author. So in this case, maybe the next Rembrandt project, that masterpiece, that painting, so to speak, would have received copyright protection if it was in India, because the algorithm worked together with humans, or humans worked together with the algorithm. So it would have received copyright protection while it in India. So that is the position of India, and so it is, you know, copyright is a territorial right, and they have their way of handling it. So that is what they have decided. So this is a bit off. This is not related to copyright. This is patent, but it is the same applicant who made the application to the US Copyright Office, and they wanted to get a patent for what I would call they call it the device for autonomous bootstrapping of unified sentience. That was the name of the AI system, and it was being used to invent something, you know, something like a food container. So there were criticisms over the grant of this patent. South Africa does not have still out, but generally that is the South African position on patents generated by AI. So what is next? What do we do? Because we have this, what we may be calling an elephant in the room, or whatever it is. So when we talk about having the programmer as the author, the programmer is the person who writes the code of of the algorithm, the computer programmer. This it's a tricky position to adopt, because you find that copyright protects computer programs as literary works, as copyright works. So the algorithm when it goes ahead and develops a copyright work, or let me call it a work, it is entirely different from what the programmer developed. So that one is not a tenable position, because the programmer just develops the program, or rather the algorithm, but then the algorithm goes ahead and develops the copyright, the work. So that one is not a possible way to look at the issue. And some people have also argued that the user of the AI is the one that is supposed to be considered the author. In this case, if, for example, I go to a shop that sells robots or machines that are AI programmed, and I buy it, and it is able to develop, maybe to print out pictures of something very spectacular, and I come with it to my house, and as a user, I activate it, I play the start button, and the machine starts churning out these beautiful pictures. Then I'm considered the author. So in that case, this is also it is also a tricky position to adopt, because what role am I really playing? What creative choice do I even have in the first place? Because what I'm doing is just activating the machine, or the AI system, and then what it's doing. So I'm not really doing anything constructive. There is nothing that I'm putting into the creation of that work. So that one is also a not very good position to adopt. Some people have also said that the data owner is supposed to be considered the author. So as we heard from the previous discussions, the data, the AI crawls on that data, and it mines on it so much that it's now able to learn from it, and then it's able to create its work. But then this data, it could be photos. Maybe somebody wants to train an algorithm to be able to make photos of me as Faith. So I own my photographs, and then I allow this person to train the AI using my photographs. So how is it that I'm supposed to be considered the owner? It is not very tenable, because my claim to the resulting AI generated work can be sufficiently compensated by way of licensing, or maybe sell. I could say, okay, I'm selling my photos to you so that you can use them to develop to train the AI. But it is not really tenable to have me as the author, because what I did was just to give my work to be, or my photos to be used. And then the work made for hire is also another option, which Mr. Teller was trying to put across in the US copyright application, and it was rejected. And I think it was rejected rightly, because when you take that approach, you open up a can of worms, because it means having a contract with an AI, with an algorithm, which is not really something that you want to get into. When we look at the definition of an author in the Copyright Act, it includes it defines an author as the person who is behind the making of a particular work. So it goes ahead to state who an author is in a computer program, who an author is in a literary work, and all that. So it talks about a person, and when we look at the definition of a person in the
Sorry, I would like to request the admin to mute everyone else apart from the speaker. Okay, thank you. You can go ahead. You can go ahead.
Yeah. Yeah, so I was saying that when you look at the Interpretation and General Provisions Act of Kenya, it also provides who a person is. And under that definition, it includes, of course, the human person, the human being, and the corporate or the corporate bodies and companies. Those ones are considered as persons. So it does not include an algorithm or a machine as a person. So if we take this approach, it becomes very complicated, because we are going to talk about, having contracts with AIs, and this is not something that you want to get into. Corporate and human personhood. Okay, some people have argued also that you can assume that the AI is a corporate or is a corporate entity, and of course this one also can't work because of the same reason under the work made for hire. Now, some people have also considered that this could be considered a derivative work, so that the work that was used or the data that was used to train the algorithm is considered the original work, and then the work that is developed by the AI is the derivative work. Now, the challenge with this is that this is not the way derivative works are developed. A derivative work is usually just an adaptation of a previously existing work. For example, a photograph being made into a painting. But when you look at how the AI works, it takes the data or the photo that it is quote unquote fed with or fed on, and then it learns from it and draws its own inspiration from it, and then it goes ahead and develops something totally new. So it is not a derivative work, so to speak, and so that point cannot also work. And then some people have said that since these are not copyright works, since they do not fulfill the conditions, then they should just be left into the public domain, and nobody should be bothered about them. Let whoever wants to develop AI works, let them develop them, and they will be there for everybody to just use and enjoy. But there's a challenge with this also, because there is a lot of investment that goes in the development of AI, from the training and everything else that goes into it. A lot of money is put into it, and it's not fair, looking at it from an economic perspective, to just let such works be left to be used freely by anyone. So my personal recommendation is that probably there should be a consideration of having a sui generis sort of protection, which is not the traditional copyright way of protecting copyright works, but something in between that takes care of the investment that has been put into the work, that has gone into the development of the AI and the resulting work, and maybe a short period of time, as opposed to the traditional 50 years plus life. We could have a short period of time, maybe 8 to 10 years, just to enable the stakeholders who have invested so much in it, to recoup their investment and offset those costs, and at least enjoy that monopoly for that short period of time. And so I will end there. Thank you so much for your time.
That was very insightful. Colleagues, participants, we've learned quite a number of things, and how actually AI is taking shape in Kenya, and even out there. I think for me it was very interesting to see that painting that was actually done by AI, and then it was a whole problem on determining who is the copyright owner. So of course, later on when we'll be looking at the next steps, we should be asking ourselves these questions, yeah? Who should own this copyright? Faith has given us some of the different perspectives. Is it the programmer, to be the author? Is it the user as the author, and so on and so forth? Yeah, and of course the consideration that Kenya as a country we can take, which is saying is non-traditional to the way copyright takes shape. Sui generis, yeah, sui generis. For me, that's a new word, but at least now I know. If you want to take care of the economic aspect, to protect the investment that goes in place for artificial intelligence, we definitely need to have a discussion on the type of copyright. So thank you so much, Faith. Again, colleagues, ask your questions. If you have any clarifications, if you have you want to add on to what she has said, you can put it on the chat box, and we'll look at it at the end. So at this point in time, I would like to now bring in other legal colleagues, legal counsel. We have lawyers from CPIT. CPIT, if you remember, CPIT stands for Center for Intellectual Property and Information Technology. So we have two colleagues who are going to help us to identify any policy or legal gaps. And to start us off, we have Cynthia Nzuki. I can just give a brief biography of Cynthia. Cynthia is a research assistant at the Center for Intellectual Property and Information Technology, that's CPIT, and she holds an LLB degree from Strathmore Law School, and her interests are intellectual property law, and how IP rights can positively impact individuals and the society through the advancement and growth of innovative and creative sectors, and to lead to economic growth. So she's coming in with all this interest from where Faith has left us. What kind of benefit or investment is going to fall onto these inventors of this artificial intelligence? Welcome you, Cynthia. After Cynthia, maybe just so I can also already just give a biography of the next speaker, because they're doing a joint presentation. Michelle Ondili is also a colleague to Cynthia, working at CPIT as a research assistant, and she's also a lawyer and a technology policy expert, tech policy expert. Her primary areas of interest are the impact of internet communications on democratic practices, open data, artificial intelligence, and the public digital space. So Cynthia and Michelle will be giving us insight on what needs to be done. If there are any legal gaps, if there are any policies in place, they will highlight that. So welcome, Cynthia. Please go ahead. We can't seem to hear you, Cynthia. Is your mic on? Yes, a little bit better, but maybe if you could just try and, I don't know, put your microphone closer. Sorry, we now lost you completely.
Better now?
Much better.
Right. So as mentioned, I'll be doing this with we are research assistants from the Center for Intellectual Property and Information. I'll invite Michelle to. Yeah.
All right, I think I can take over from here. I hope you can hear me, and if you can't, just you can just quickly let me know in the chat. So
no, we can hear you
me?
clearly, Mitchell. Thank you. Right.
Okay, great, fantastic. So my colleague has introduced us, and we've also gotten an introduction from Arnold. Thank you for that. So basically what we want to talk about specifically is trying to link the two aspects of TDM and copyright protection specifically in Kenya. So we will be pointing out some of the gaps, some of the opportunities for change or opportunities for further research. And I'll rely on Cynthia's coordination with the slides. So if you can just move to the next one, we can get started. Okay, is there anybody who can't hear me? Because I can.
You're good to go.
All right. Okay, sorry, I'm relying on Cynthia for the slide, but let me just see if I can share it on my end, if that would be better. Okay. All right, I can't seem to be able to access the share tray.
Yeah, we could see it clearly when Cynthia was sharing. I don't know, maybe.
Okay. All right, I think that's why. This should be fine now.
Yeah.
Okay, so just we've already kind of had a bit of an explainer, but to put it in a context that I think can be very specific to what we're talking about, what we really are saying is that when these automated these forms of automation extract this data from, in digital form, which are intended to generate information. And this information is patterns, trends, correlations. And so when we're talking about it in the sense of research, there's kind of two main factors here. So one, it's that it does have to be that the content that it's extracting all this data and information from has to be recognized as kind of legally shareable, legally protected. So mostly this is because we're trying to avoid the issue of not just blanket stealing, but really intellectual property is a matter of innovation. So if you discourage people from being able to access or to hold certain rights over the work that they create, then they stop being incentivized to create that work. And when we're talking in particular instances about where that work can lead to certain commercialization, so text and data mining in instances can be used to develop products, it can be used to develop income generating information. So when we're dealing with this idea of TDM and trying to protect rights holders, we're talking about an intersection of the importance of research, but also the importance of recognizing that legally there should be this lawful access, even if the research is going to lead to one positive facet or the other. So this access that we're talking about, it has to be based on an open access policy. And this is primarily, or it can be through licensing. So this is a contractual arrangement that is happening between the rights holder and the research organization and the person that is conducting the TDM. And so there's other means. So sometimes, for example, if you're using repositories, you will pay a certain fee. If you're using different sources of information, you are supposed to give to either in terms of acknowledgement or in terms of actual compensation that the rights holder is the person that is giving you access to this. So when we talk about some of the gaps that are emerging, because TDM is a process of extracting these very large bits of data, some of this data isn't necessarily easy to determine the source. So I think we can move on to the next slide. So one of the kind of really bigger problems is about orphan works. So basically an orphan work, it's a work that the copyright holder cannot be determined. And so they haven't been recognized. And because they haven't been recognized, they can't be given their attribution or they can't be able to exercise that legal right. So there are instances where TDM it's unable, for example, for the conclusions that have come from that data mining to be used because there's a chunk of that data or some of that data which isn't subject to that lawful access that we're talking about. So you can't actually use it because you haven't established this legal relationship between the rights holder and the person who's trying to extract this data. And then the other thing that we're kind of very concerned about is that really there are irregular legal copyright agreements. So in a typical TDM workflow, there's 3 levels of licensing compatibility. So we're talking about the tools, the content, and the service. So the content is the resources, the literary works. We're also talking about sound data, images, databases, and then the tools are the actual programs. So it can be the software that is implementing the algorithms. And then at the service level, we're talking about, so when TDM is being performed, it's not just being performed kind of in a very isolated, siloed way. So there are instances where, for example, this data will have to be uploaded to a cloud, or there are certain instances where the data, if the person themselves isn't the one hosting the data, it's going to have to be uploaded to other external users or other external sources. So this means that you are dealing with multiple licensing agreements across this one particular workflow. And if there's an incongruence between those licensing agreements, then ideally one part can't take care of the other. So there are issues that, for example, you can have with the services. So if you're storing it somewhere on a cloud, if you're storing it on a separate application, you are subject to certain terms of service, terms of use, and especially when it comes to services, if your usage of it is curtailed by your usage of one of the first 2, so either in the content or in the tools, then you can't use the thing altogether. And this is something that up until now, it really wasn't envisioned because this multifaceted interaction wasn't something that we had to talk about as a legal problem, and to find a way to create this amount of harmony. So I think as we move on, and as Cynthia talks specifically about the context, we're going to be able to sort of see a much wider application of these problems. So I think I can let Cynthia take over from here.
Michelle. Narrow down this discussion to I'll be taking us policy gap in our that may essence hinder or try to enable next in data approach, which is quite necessary as pointed out by one building of equitable AI. So within Kenya, we have the Copyright Act, which governs and protects copyright works in our jurisdiction. The whole point of having copyright protection is to in essence incentivize creativity and to reward creatives and others of different to benefit their works and to enable them to gain economic as a copyright holder. And these rights are defined as economic rights. So the right to reproduce your work, to determine who gets to reproduce your work, the right to control how your work is.
Sorry, Cynthia.
Yes.
We seem to lose you. You're coming on and off. Would you want to get a position? I don't know. I think it's your mic, so that we can hear you clearly.
I think I'll just move closer to the laptop because you can't
Yes,
hear
please.
me.
Yes.
Is this better?
That's much better. If you could be consistent in that position, if you don't mind, yeah.
Okay, there's
Right.
no problem. So as I had pointed out, I'll be looking at we'll be narrowing down this conversation to Kenya and looking at some of the legal and policy gaps within our own jurisdiction. We have the Kenya Copyright Act, which in essence is there to promote and to protect our creative works and works of worship. And once a copyright owner receives their rights, they receive certain rights known as economic rights that allow them to decide how their work will be reproduced, decide how their work will be distributed, and how they can economically benefit from these works. So when we look at text and data mining and the need for access, free access, easy access to information and data in order to progress and to build equitable AI and allow text and data mining research to progress without hitches, essentially we will be infringing, text and data miners will be infringing on the economic rights of copyright holders while they're doing what it is that they're doing to mine text and data. So to allow and to, in order to build a balance and in order to establish a balance, because we know we need information, our Kenya Copyright Act provides for exceptions that, in essence, the exceptions list out actions that will not amount to infringement upon use. So tying all this back to text and data mining and looking at the legal gaps and policy gaps within our jurisdiction, when you look at the exceptions we have under our Act, as pointed out by Sean earlier, we do have an exception that tells us that works used for scientific research and the use of works for scientific research do not amount to infringement and do not amount to the stealing of other people's works. This is a gap in that, yes, in as much as it has provided for scientific research, that is the only provision that we have. As Sean also pointed out, there are certain jurisdictions that have highlighted and are keen and have specified different uses and where such use will not amount to infringement and to the stealing of other people's rights. So within our law, we have the gap of where we do not understand what essentially is meant by scientific research. You could have firms that will come in and economically benefit from text and data mining at the expense of copyright holders, and in the argument they would argue that they're doing it in scientific research. Another gap that we have within our jurisdiction is the lack of cross-border provisions. Within the times that we're living in, yes, information is being shared all over the world, and as such, in essence, within our law, we do not have provisions that provide for what is permissible, what is not permissible within the sharing of this information across the world. Our copyrights and intellectual property rights are enforced and implemented territorially, which means that we can only, for someone whose rights are infringed in Kenya, they can only enforce their rights within Kenya. This is an issue moving forward, seeing how we are living right now in a global world where information is being shared all over. Another legal and policy gap that we have is the lack of express text and data mining policies within our platforms. When you take a look, and when you do get a chance, have a look at some of our news outlets that put out news, which ordinarily would be sites where text and data miners would go to mine text and data. Looking at their terms of use, they do not have express provision as to what is expected of text and data miners, as to how far a text and data miner can go while they are doing their work. There is lack of sufficient knowledge and sufficient sensitization on the subject matter. Indeed, we are aware that, yes, we are living in such times, and maybe people have just left it for the industry to define for itself, but it will be helpful to have TDM policies on site, to have TDM policies that inform the users of different platforms, that when you put your information here, we reserve the right to share it with other people. Does that mean commercial use? Does that mean that you will be able to benefit? What does that mean for the users? What does that mean for the text and data miners? What does that mean for the companies and the ISPs in between? So as a means of moving forward, maybe as Kenya, we could consider expanding our fair dealing exceptions list. As pointed out, yes, in as much as it provides for scientific research, we would benefit more from it being more specific. I will still use the example given by Sean earlier, where the EU and the UK have put out provisions that are keen to text and data mining, defining what happens when that is done within a commercial space, defining what is allowed if it is non-commercial, difference between public and private use, what is allowed and what is not allowed. Again, here the point is to strike a balance between protecting creatives and protecting the authors and owners of copyrighted works while still advancing and sharing information. Or maybe we could also consider adapting fair use principles. By fair use, I'll use the example of the US. Within their jurisdiction, they do not have a closed list of what is allowed or what is not allowed. Instead, they have a list of factors where judges or people can use that list to define whether certain use of copyrighted works is fair. Secondly, we should continue to actively educate the public and continue to actively sensitize people on these matters as we move forward. How does this look like, and what do copyright laws mean for us? So with that, I say thank you, and I'll hand it back over to you, Arnold.
Wow, quite interesting. Thank you so much, Cynthia and Mitchell. I think this was an eye-opener for me and many others who are here today. I think some of the things that have been mentioned, we realize that there's a lot of orphan work, data that has not been legally, protected. So there's that gap. And I think one of the things that we expect during this brief next 30 or so minutes is to try and identify the next steps. How are we going to come up with the frameworks or policies to protect this. Another thing that maybe I just realized, speaking from my profession as a librarian, we rely so much on these corporate exceptions such as the Creative Commons, yeah, because we know as librarians we take part in this text data mining. I would call us enablers of text data miners, because you find that from our repositories we use a Creative Commons license to avail data on open access, but we do not know whether people stick to know what is meant of that data. Like I know most repositories use CC BY attribution and share alike, but you get instances where people still use this data for commercial purposes. So I think this is what Cynthia and Mitchell are trying to talk about, some of the gaps in place. And again, we need to define what scientific research is, yeah, in the law, of course, so that even as we put that data there, people need to know this scientific research, how can it be protected? And then, of course, in terms of also gaps, we've learned that there are no express gaps for text data mining. And we need to expand fair dealing exception to accommodate text data mining. The only thing that maybe I'm not sure is, if we do that, will it affect, we saw earlier on in Sean's presentation, Kenya is green. Might that now take us to yellow? I don't know. That's a question for you, Mitchell and Cynthia. And then, of course, most important, awareness. We need to create awareness on the copyright protection, copyright infringement, so that people are aware about all this. So thank you so much, Cynthia and Mitchell. And now to open up for this discussion, I would like to open up the floor. If you have any questions, if you have any clarifications or comments towards this discussion, this is the time. So please raise your hand, and we are going to give you the permission for your microphone to be on. Any questions? Meanwhile, as we get the questions on the chat box, I've seen some comment from Dominic. Dominic says that data is the core of artificial intelligence. The more data you have, the more exemplary the AI system. And he's giving an example of China and the Western world having contradicting privacy laws, yet they are the leaders in AI technology. You know, that's quite interesting. So he's asking, what would be the ideal privacy law to adopt? Should we go the China way or the Western way? I think this question I would direct it to any of the panelists. If maybe if I could start with the Faith. Faith, would you want to answer this question or give some insight?
Sorry, Arnold, I was a bit diverted. I am trying to multitask and I didn't quite get the question. Kindly repeat.
Yeah, so one of the participants, Dominic, has just given us an analogy of how in China and the Western world, they have contradicting privacy laws, yet they are the leaders in AI technology. So he's asking, what would be the ideal privacy law to adopt? Should we go the China way or the Western way?
Okay, thank you for that question. Well, I may not have the perfect answer for Dominic. So I hope I got his name right. But you see, with data protection and privacy issues, there are a lot of concerns or let me say challenges that still come up with it, because there are principles of data protection which include data minimization, storage limitation, and that kind of thing. So when we talk about data that is being used to train AI systems, for how long are you going to to keep that data? Because under the data protection principles, you need to keep it for as short as possible, and then you delete it, or you let it go. So it is not such an easy question to answer, because it involves a lot of dynamics. And I think for China and the West, they have adopted what they've adopted because it works for them. And I think Kenya needs to find her own appropriate system that would be suitable for her, you know, taking into account all the actors, taking into account, you know, data protection principles, taking into account copyright and, you know, the exceptions and limitations that we have in the Copyright Act and other constitutional rights that may arise when we are talking about this, because we have the right of access to information, which is intertwined in this whole thing. So I may not have the perfect answer, but I think Kenya needs to, Angeline, sorry, she mentioned at the beginning that there was an AI and blockchain task force that was constituted sometime in 2018, 2019. They did what they did, they delivered their report, but what happened after that is not known. So it is such task forces that should be giving a way forward, like, well, this is the new technology that we have and it's very beneficial, but how do we go about it? How do we make sure that it benefits us within the law? Let me say within the laws that we have. So I can't say we go the China way, we go the Western way. We need to find our own balance and what works for us.
Thank you so much, Faith. I think, Dominic, you've gotten an answer from Faith. And I would also encourage, if anyone else, I can see Sean has left, but Angeline is here with us. Angeline, do you want to, you know, add on to what Faith has said? Or do you have a different view?
Yes.
Please go ahead.
I'm in line with what Faith stated. I think we need to be careful in how we define success when it comes to AI. I do agree that data is the backbone of AI, and without it, we can't really develop our tools. But when we say successful AI, do we just mean in terms of quantity, you know, or do we mean in terms of doing no harm? So we do have a lot of applications that come from the States and more that are coming from China. But what we also have seen is that there tends to be issues of inherent bias in some of these systems. So would we still consider that a successful AI application? So I think we need to define those terms first. And then in terms of laws regulating AI, there is always that pull between laws that protect human privacy and laws that also power innovation. So you want to protect one without hindering the other. There really isn't an easy answer, like Faith was saying. I would always skew towards more human-centered laws, meaning laws that maybe look out more for us than they do, than are concerned with innovation, only because I believe there is a great concern that these laws, without them regulating how data is used and how data is collected and how data is protected, there's a great chance that there will be data exploitation and the people that will be harmed will be us. And without laws, there's no redress for us. So I would skew towards more human-centered approaches, I guess, rather than commercial approaches. But that's just me. And, you know, there's a lot of things to think about.
Thank you. Thank you, Angeline. I can see some hands up. I'm going to, let me just put them in order. I'm going to start with I'm going to give a chance to Rosemary and then Stanislaus. But before that, there's a question from Dr. Njoroge, who is a university librarian at Kenyatta University. So Dr. Njoroge says AI is here with us to stay. In fact, it might replace conventional human tasks in the very near future. What could be the way forward if copyright and patent law do not protect AI? AI-based interventions, and what other alternatives can protect the AI-based inventions rather. I would like to invite Cynthia and Mitchell, because they've actually given us some of the gaps and policies in Kenya, and I believe they would be the best to answer this question. Over to you, Cynthia and Mitchell.
I think I can take this one.
Yeah.
So I'll go back to the presentation made by Faith. We have the capacity to not that we have the capacity. When she was listing out ways in which that AI could be protected, she mentioned sui generis ways. So we could think of coming up with a unique way that's unique to AI, that's unique to the structure of AI in order to protect AI. Additionally, we have trade secrets, which are often used by it's majorly for commercial purposes, where an institution or a company will choose to have their intellectual property as a trade secret within their company. But this could go very widely. It's a point of discussion. At the moment, the systems that we do have are copyright and patent, but we could also be thinking of sui generis systems and other ways. Thank you.
Thank you, Cynthia. That's very nice. So we have it, sui generis, Dr. Njoroge. That could be the answer for us. So Rosemary, please ask your question. Just unmute yourself. Okay, Rosemary, are you still there? Okay, right. Let's go to Agava Stanislaus. Please ask your question.
Arnold, can I ask now?
Oh, go ahead. Yeah.
Okay. Sure. Okay. My question is, I don't know who it's directed to, but the panel will decide who to answer. So there's been widespread of use of drones, which is an artificial intelligence gadget. I just wanted to find out who owns the copyright to drone photographs and video footage. Thank you.
Thank you, Rosemary. Panelists, it's open. If you feel that's your question, just take it. Okay,
I think I can.
Yes, please. Go ahead.
Yeah. So the way that it works is it's pretty much, let's say, the same way as if you're using like another tool that's related to like videography, that their copyright belongs with the person. So for example, if I'm the person who owns the drone and then I'm taking whatever footage, whatever recordings, then I am the person who gets the ownership. It doesn't really have to do with the drone itself. It really goes to me. It's really the same principle as if you own a camera or if you have like if you're recording something on your phone. So personally, like the person who is taking the video footage is the person who gets the copyright.
Thank you for that answer. I think Rosemary, you're satisfied. So now we'll go to Gava.
Thank you very much. I don't know if any of the panelists had addressed this, but my question is, could we identify weak legal framework as a country as a drawback to the adoption of AI and data and so forth, something related to that? The processes put in place to put in place legal framework are a little bit weak, or the legal framework that we have in place is a bit weak. Then number two, could the situation we're having currently, could data literacy framework be an option to educate the masses, particularly on issues to do with AI and data? Because in that context, you'll capture copyright and all the related issues. Thank you. Arnold, you're muted.
Sorry. Thank you, Stanislaus. I would like to direct that question to anyone from CPIT, if you would like to answer that question.
I think I can just start and then like leave open the floor for Angeline and Cynthia. I think one thing is that what is encouraging or discouraging AI in the country isn't necessarily a matter of law. So it's really more an infrastructural issue. We do have a lot of AI applications, inventions, startups that are happening in the country right now, but the law usually tends to catch up. So the law comes after, and the only laws that can be restrictive are laws that, for example, can be tighter on certain data controls or tighter on certain like different, for example, frameworks or different ways that data can be used or mined or extracted. But generally, the use of AI will come prior to the law. But secondly, when we're talking about issues of information and access to information to the public, one that is it's a duty, especially when it comes to these things that have automated decision making, is something that is going to play a very big part in very ordinary processes of our lives. So the criminal justice system, decision making, especially in terms of governmental processes, this is kind of an example that we're seeing from other countries. Simple things as, will you be given the access to be able to get a loan facility? Are you going to be able to get a mortgage? And there are people who use algorithms to calculate whether or not you're going to be able to. And all of that is something that people don't know about and aren't informed enough about. Having a law to provide specifically for education on automated decision making, on the use of algorithms and AI, it would help. But really, in practice, all laws have to be complementary enough of each other so that we're not kind of doing this this kind of omnibus framework where we're just kind of allowing everything to be subsumed under one law, but more so that we have these, maybe a standalone law that is very general, but from it we can have different subsections that specifically deal with AI.
Thank you, Michelle. So I think the question, yeah, please go ahead, Angeline. Yeah.
I was just going to say, just to add on to that, for the question about knowledge and education on data and data issues, I think the problem is who's going to take the ball with that. Will it be the private entities? Will it be government? I think that's something we need to strategize out. So right now, I think even fundamental knowledge on data is missing, let alone specific knowledge when it comes to things like data utilized for AI, or even concepts like data justice. I think just fundamental knowledge on data is missing, and we need to address that from a ground level up. Otherwise, what tends to happen is the same voices are steering every one of the data processes, whether it's in terms of legal issues or in terms of technical issues, because we're the ones who have knowledge with it, and that leaves a huge chunk of the population out. So data education frameworks are needed, but the question is who's going to do it and how can we do it effectively. I also agree with Michelle in terms of innovation coming far ahead of the legal aspects of it, but I think the concern there is also that in that case we run into a situation where a lot of issues that arise are not really protected by legal structures, right? So we have data privacy protection under the DPA, but the way AI works is a little bit different than regular technology. AI, so we have a type of AI called neural networks, for example, and this means that the data can be shared incidentally, like data that wasn't meant to be shared is shared as part of another process. And I'm not sure if that's covered under the DPA. Like there's a lot of ways that AI works that's not what we've really seen with other technology. And legally what happens then, and that's of concern.
Thank you, Angeline. I think that was really comprehensive enough, and colleagues, we can see that those are some of the next steps we can take in this way, that we've established their gaps, and we know some of the ways in which we can address these gaps. So at this point, I can see we're remaining with only 7 minutes. I'm sure this is a discussion that can go on and on and on, but I encourage you to continue having these discussions. Go on Twitter. Kekobo have started a thread. Answer, retweet, just get part of the conversation in terms of creating awareness on these copyright cases in AI TDM, and big data. So at this point, I would like to invite somebody from Kekobo. I don't know who that is going to be, to just give us some remarks. And then after that, I will invite IFL corporate coordinator, who is Teresa, to come and also just give us some remarks and what is going on from their side, what they're doing together with WIPO regarding these copyright exceptions and recognitions for TDM and big data. So I don't know who we have from Kekobo. I know Sige is not with us today. Kekobo, do you have somebody from your side?
Arnold, Sharon was here. She's the Deputy Executive Director, but I think she has left. I can't see her among the participants. And so I don't know.
Please have the honors. You're representing now the Deputy Director and the Director, so I've given you that. Please go ahead, yeah.
Okay, thank you very much, Arnold, for coordinating and moderating this session very ably. And big thanks to also to all the panelists, Mr. Sean, who left, Angeline, as well as let me just, I'm usually very bad with names, Michelle and Cynthia from CPIT. Thank you so much for your valuable input to this debate and for honoring us with your presence during this webinar. I also wish to thank all the participants for taking their time. I know it is getting a bit late and some of our roads are very busy, and if you are still in the office, maybe you're thinking you might get home very late, but we thank you for staying with us until this far and for, being actively, participating actively. So we are really grateful, and I also wish to thank the organizers, IFEL and of course Kekobo, the ICT team, for making this possible and for sharing this and making it work. I also wish to thank the public communication department of Kekobo for putting the word out so that people were aware of this and they were able to join us today. So on behalf of the Executive Director, Mr. Edward Sige, I thank you all for joining us today. Have a nice evening or have a nice day, depending on wherever you are. Thank you so much.
Thank you, Faith. So before I invite Teresa to close for us, I would like to recognize some of the participants. I think it's an honor to see not just policymakers here. I'm seeing some policymakers, I'm seeing librarians, I'm seeing lawyers, and I'm also seeing some colleagues from Zimbabwe. Kathy Matsika, thank you for joining us. It would have been great to get some insights from Zimbabwe and how what is in place in terms of copyright for AI, TDM, and big data. But I think next time we'll give you an opportunity. So I'd also like to recognize the CLISC fraternity. This is a Kenya Libraries and Information Services Consortium, which comprises university librarians and copyright leaders. We have copyright specialists. I can see Elizabeth, I can see Esther, I can see Alan Musili. Yeah. So thank you for joining, and I encourage us to continue having these conversations. And whenever we get a time, let's create awareness on some of this copyright, awareness information. So over to you, Teresa, and thank you, colleagues. It's been great hosting this event, and I wish you a good afternoon.
So good afternoon, everybody, and thank you so much to Arnold for chairing this session. So IFL, to conclude the session, IFL would like to thank Kekobo for hosting the webinar on artificial intelligence and big data, as well as CLISC, our library partner in Kenya, and the project on the right to research and international copyright law. Today we've discussed two aspects of AI, the outputs and the inputs. And the outputs involve questions around ownership of AI-produced content, like the picture of Rembrandt that we saw earlier. And these questions about ownership are open and very much an area that's evolving and to be watched, you know, around the world in how these issues are being handled. And then in terms of the inputs that involve the information and the data needed to feed into computers, to train the machines to learn from past and similar experiences, described by Angeline as the data being the backbone of artificial intelligence. So we heard from Professor Sean and our colleagues at CIPIT that the Kenya copyright law does indeed have a fair dealing exception that is helpful for text and data mining and the right to research, but it could benefit from clarification in certain aspects, and maybe even for the copyright law to have a specific right on computation, like we have seen recently in Singapore and Japan. And Mitchell also mentioned the important area of orphan works and the need to enable the use of orphan works for artificial intelligence, and cross-border provisions to facilitate cross-border projects. And the WIPO Committee on Copyright is discussing the issue of exceptions and limitations at the moment, including exceptions and limitations for text and data mining as well. And then very briefly, in terms of next steps, I mean, one idea that came up was that perhaps we could develop some guidance on these issues, you know, mentioned copyright literacy for artificial intelligence and TDM, so that researchers and text and data miners in Kenya know their rights under the law and what activities are lawful. And this could maybe tie in with a previous webinar we had with COBO in February on fair dealing and the other exceptions more generally. So I would say let's keep talking, and maybe we can work together to come up with some guidance for researchers and librarians and others in Kenya that are using the copyright law for these purposes. So with that, I would like to thank once again our speakers. I would like to thank our chair, Arnold, and we will share the slides and the recording afterwards, and I wish you a very good afternoon. Thank you.
Sorry, Teresa, would you want to take a screenshot for the web?
Sure.
So how many, I think if people are able to put on their cameras.
Okay, thank you. Yeah, so everybody who has camera access, put on your camera maybe, and we can try to take a screenshot. Lovely. I'm seeing you all. Is Angeline still there? Mitchell?
Yes, I'm still here. Slight technical difficulties, but I think the camera is coming on. Okay.
Yes, you're coming on. Yes, lovely. We can see you. Is Mitchell? Yes, Mitchell. Excellent. Okay, that's great. Now I have a in the middle of my screen, like I have a kind of a bar. I'm not sure